In this video, I'll be discussing some important case laws in relation to occupier's liability. And in my previous video, I have described how to write an answer for a problem question on occupier's liability, but there I have not mentioned about case laws. So these are some of the important case laws that you should include in your answers. So first of all, let us see the important case laws under who is an occupier. So as you already know that an occupier is not defined in the 1957 or the 1984 Acts on Occupiers' Liability. So we have to depend on case laws in order to define who is an occupier. The main case with regard to this is the case of Wheat and Lacon. So what happened in this case was Lacon and Company Limited owned a pub and they allowed two managers, Mr. and Mrs. Richardson, to live in this pub and to rent out rooms to paying guests. And unfortunately, one of these guests fell down an unlit staircase without handrails, and the issue to the court was whether the managers were the occupiers of the premises under the Occupiers Liability Act 1957. So here the court said both the managers and the pub owners could be occupiers. The reason was that the court said it's not just the owner of a premises that could be considered as an occupier, but any person who exercises an element of control over the premises can be considered as an occupier. So what we can take out from this case is that an occupier is a person who exercises an element of control over the premises, and it is not necessary for a person to have entire control over the premises. So whenever you want to identify an occupier in your problem questions, please refer to this case and use it as the authoritative case to say that it is not just the owner who is considered as an occupier, but any person exercising a degree of control over the premises can be considered as an occupier. Next case is also important, that is the case of Harris and Birkenhead Corporation. What happened in this case was the Birkenhead Corporation, which is a local authority, issued a compulsory purchase order on a house, which means the local authority had the legal right to take possession of the property. And the previous owner, once he received this compulsory purchase order, he moved out of the house, but the local authority never took the physical possession of the house. And in the meantime, a 4-year-old child entered this abandoned house and he fell from a window and suffered serious injuries. So the issue here was whether the Birkenhead Corporation, the local authority, was an occupier, and they did not have the physical possession of the property, but they just had a legal right over the property. So the court held actual possession is not required to be considered an occupier. So the local authority was held liable for the injuries suffered by this child. They did not have the actual possession, but they had the legal right over the premises. So this case can be used to show that in order to recognize who is an occupier, there need not be actual physical possession, but just having a legal right over the premises is also sufficient. Next, let's see a case which explains who is an implied licensee. Again, under the Act, we can't find a definition of who an implied licensee is. The 1957 Act just gives 4 categories of lawful visitors, namely invitees, licensees, people entering pursuant to a legal right, and people entering under a contract. So the case of Lowery and Walker explains who is an implied licensee is. So in this case, the defendant named Walker owned a field which was frequently used as a shortcut by the public for over 35 years. And he was aware that people regularly use this land as a shortcut, but he did not take any steps to prevent them. And one day, Walker placed a dangerous horse in his field, knowing that people still use it as a shortcut. And this claimant named Lowery, he was walking over the land and was attacked by this horse and was injured seriously. So the issue was whether Lowery was a trespasser or an implied licensee. Implied licensee means he impliedly had the permission to be on the land. The question is, did he have the implied permission? The court here held the claimant did not have express permission to be on the land, but a license was implied through repeated trespass, the defendant's knowledge that the horse was dangerous, and his failure to take reasonable steps to prevent injury. So this case goes on to show that we can consider a person as an implied licensee if there was repeated trespass, if the defendant had knowledge that there is something dangerous on his premises, and if the defendant, that means the occupier, has failed to take reasonable steps to prevent an injury. So in this case, all these three were satisfied. Therefore, the court said the claimant, Lowery, was an implied licensee. Therefore, the occupier owed a duty of care under the 1957 Occupiers Liability Act. Next, let us see what is the duty of care and what are the cases that shows the standard of care expected from an occupier. In the case of Fryer and Pearson, a family visitor was injured by a needle when kneeling on floor. Question to the court was whether the occupiers have breached their duty of care, which resulted in the injuries to this visitor. But the court said the occupier had not breached the duty as there was nothing to suggest they knew the needle was on the floor, and it was not something they could have reasonably foreseen. So what this case holds is that the duty is to keep the visitor safe and not to maintain safe premises. So obviously we can't expect an occupier to have his premises 100% safe all the time, but we can expect an occupier to take necessary action in order to keep a visitor safe for the purposes for which the visitor is on his premises. So this is an authoritative case which you can use to show the standard of care that is expected from an occupier towards his lawful visitors. In the next case, Ward and Tesco Stores Limited, the claimant, Mrs. Ward, has slipped on a puddle of yogurt in Tesco supermarket and sustained injuries. So you can compare this case with the previous case where it was a needle and here it was a puddle of yogurt. So can an occupier foresee a risk with regard to a puddle of yogurt? Obviously, yes. So considering that, the court said Tesco was liable as a greater duty is owed by a shopkeeper to their customers. They have not taken reasonable care to ensure the customer's safety. Therefore, the Tesco supermarket was held liable under Occupiers Liability Act 1957. Moving on, let us now look at some case laws which discusses the occupier's liability for children under Section 2, subsection 3, paragraph A of the Occupiers Liability Act 1957. So you know that under the 1957 Act, there are three special situations of duty of care. The first one is children, and then we have about skilled visitors and independent contractors. So in this video, I'll discuss some important cases with regard to children, and in my next video, I'll explain about the law which is applicable for skilled visitors and independent contractors. When children are involved, the law expects the occupiers to take extra care in order to protect the children on their premises. So in the case of Moloney and Lambeth Borough Council, a 4-year-old child fell through a gap in railings guarding a stairwell and he was injured. An adult couldn't have fallen through the gap. That was the argument of the defendant. But the court said the occupier was liable as the premises must be safe for children. So what we can take out from this case is that Section 2, subsection 3, paragraph A of the Act warns that children are less careful than adults, and it implies greater care should be taken in order to protect children from harm. So whenever you get a question in relation to children on premises, you have to apply this section, Section 2, subsection 3A, and this is the authoritative case you can use to say that occupiers are liable for injuries suffered by children on their premises if the premises were not safe for a child. So you can't just say that the premises were safe for an adult. You will still be liable if the premises were not safe for a child. And in the next case, Phipps and Rochester Corporation, a 5-year-old child was playing on a land under development by the local council, and in one occasion, he fell down a trench dug by the council and suffered injuries. So the question was whether the occupier was liable, the local authority was liable for the injuries of this child. Here the court said there was no liability as the defendant could not have been expected to protect against unforeseeable risks. So why is this an unforeseeable risk? Because the child was playing on a land under development, and an occupier may not expect a child to use such a land as a playground. So we have to divide the duty of care towards the child between the occupier and the parents. So the court said the defendant is entitled to assume that parents would take primary responsibility for safety and control of their children from obvious risks. Therefore, you can use this case as an authority to say that it is not socially desirable for parents to shift the burden of protecting their children from harm from themselves to the occupiers. In this case, Taylor and Glasgow Corporation, another principle was pointed out by the court, and that is known as the allurement principle, or you can call it the principle on concealed dangers. So whenever there is a concealed danger on your premises, and if you know that children are coming to the premises, the occupier has a greater duty of care to ensure that the children are safe. So in this case, the defendants own the Botanic Gardens of Glasgow, which is a park open to the public, and a boy of 7 years ate some poisonous berries from one of the shrubs. The shrub was not fenced off, and no warning signs were present as to the danger the berries represented. So the court held Glasgow Corporation was liable because the children were entitled to go onto the land and the berries would have been alluring to children, and it represented a concealed danger. The defendants were also aware that the berries were poisonous, but they had taken no steps to ensure the protection of the children. There were no warning, no fence, or nothing was done for the protection. So the court said that a duty of care will exist if land holds concealed dangers or allurements that tempt children into danger. So in this video, we just discussed some case laws which are important to explain who is an occupier, who is an implied licensee, and what amounts to duty of care and the standard of duty that is expected from an occupier towards the lawful visitors, and some important cases showing the degree of care that occupiers owe towards children on their lands. In my next video, I'll describe about the skilled visitors and the independent contractors. Until then, stay in touch and please subscribe to the channel if you found this video useful. Thank you.